good morning and good afternoon to in-house counsel from all across America. Welcome to In-House Connect. My name is Shai Mahani, and I'm the CEO and co-founder of In-House Connect, and I'm thrilled to have you here with us today. Thank you for spending your lunchtime or your breakfast time with us, and special thanks to our wonderful sponsor, Pryor Cashman, and our fantastic presenters today, Jeff Alberts and Sid Kamaraju, for putting together a fantastic presentation on how in-house lawyers can stay on the right side of OFAC and FinCEN. For those of you who are here for the first time, let me give you a quick bit of background on In-House Connect. In-House Connect started 11 years ago as a New York City-based meetup group for in-house counsel. Every month, In-House Connect would organize free CLE classes, which were followed by cocktail networking receptions. And every 6 months, we would organize fun and festive networking mixers. Over the years, we've helped thousands of in-house counsel connect with peers and outside counsel alike. Well, the group was humming along, and then, of course, COVID hit. We couldn't meet in person, so we went online, and it's been a fantastic transition. We've been able to attract a much larger audience of in-house counsel, truly from coast to coast and sometimes around the world. And we've been able to feature high caliber speakers like the two we have today, who I'm going to introduce in just a few moments. This is our 27th event of the year thus far. And I'm wondering, is this your first IHC event? Let me know in the poll. I see we have 30% new attendees, so welcome. It's great. And thank you for not screwing up the math. And hello to the 70%. It makes my life easy. All right, today's event. Sanctions and export compliance for in-house counsel. Russia sanctions, how in-house lawyers can stay on the right side of OFAC and FinCEN. Our first panelist today is Sid Kamaraju. Sid is a partner in Pryor Cashman's white-collar defense and investigations, financial institutions, and litigation groups. Sid's practice focuses on criminal defense, regulatory investigations, complex litigation, cross-border litigation, and advisory services. As a seasoned white-collar defense attorney and former federal prosecutor, Sid has extensive experience with corporate security matters, internal investigations, regulatory inquiries, asset forfeiture actions, and criminal prosecutions. Sid has tried numerous high-profile criminal cases and argued several significant appeals. Our next panelist is Jeff Alberts. Jeff co-heads the firm's fintech group. In this role, Jeff represents blockchain, digital currency, payments, and fintech companies on a wide variety of regulatory issues. Jeff regularly advises clients concerning money transmission, securities offering, anti-money laundering, prepaid access, consumer credit, privacy and data security, and payment processing regimes. He also represents fintech clients in responding to regulatory inquiries, and is as well a former federal prosecutor. We are so fortunate to have such an esteemed panel on today to help us stay on the right side, OFAC and FinCEN. And with that, I'll turn things over to Jeff and Sid to get us started.
Awesome. Thank you, Shai. So it's great to be back at In-House Connect, and Sid and I are super excited about this presentation. We both used to be federal prosecutors and conduct cross-border investigations, and now we work with in-house counsel that are trying to figure out how to respond to everything that's going on in the sanctions regime related to Russia, as well as the similar FinCEN regulations that have been promulgated that relate to those same Russia and Belarus sanctions. So we're going to go over the law today, but our main goal is to give you practical takeaways. So, you're sitting here, you're in-house counsel, you've heard a lot about these new sanctions regimes that have been imposed. And what we'd like to do is help give you some information about what you should do in response to all of that information, and some practical steps that you can take to make sure that your company doesn't somehow run afoul of the sanctions regime. So we're going to start out with a background on sanctions. And it's interesting because you hear a lot about new sanctions being imposed. And over the past few years, you primarily hear about that as if it's a law enforcement technique. But sanctions have actually been around for over 100 years, and they were primarily a tool of US foreign policy. So they were used by the State Department and often in connection with military efforts. So we're now seeing that as an activity that the US government is engaged in relation to the invasion of the Ukraine. And people think of that as, oh, I thought that sanctions were related to terrorism. Why are they now being applied to a war effort? But actually, sanctions were primarily used in connection with foreign policies and war efforts in the past, including World War I and World War II. And then it wasn't until the late 70s that the US started to use the US sanctions regimes to attack other problems like terrorism, cyber attacks, ransomware. And that's how it's come to be thought of more as a law enforcement technique, because many of the times that sanctions are imposed in connection with cyber attacks or ransomware, it isn't state actors, it's private actors, and it's really criminal schemes. But in fact, you should think of sanctions as being something that is very much used as foreign policy, not just in connection with law enforcement. So that's a little bit of background. It's helpful to kind of know where the sanctions regime is coming from. And I'll talk to you later a little bit about where FinCEN and FinCEN regulations are coming from in relation to the Bank Secrecy Act. But to get into the nitty gritty, I'm going to turn things over to Sid. But before I do, and before Sid goes through the legal background, we're going to do our first poll. And the poll is, has your company had to address sanction issues? You've got three options. No. The second option is yes, we've addressed sanction issues. And the third, which, we still don't have any hits, is yes, we do have to address sanctions issues, but we chose not to address them. And I'm conducting illegal transactions right now. So far, still 0%. It'll be interesting to see how many hits we get on that. And now I'll turn it over to Sid.
Great. Thanks, Jeff. I appreciate that. So, one of the things I think it's interesting from the poll, it seems like we've got a mix of folks who have had to deal with sanctions issues, but also are new to the subject. And so I want to pick up on something Jeff said, which is sanctions as a tool of foreign policy, because I think for in-house counsel, that has two really significant real-world consequences. The first is that sanctions are reactive, like foreign policy, and so they're constantly being tinkered with and sometimes can appear out of the blue. And the second, and this is sort of a scary corollary to the first principle, is that in many cases, at least with respect to civil penalties, sanctions violations are what we call strict liability offenses. So even innocent mistakes can bring you in the crosshairs of government regulators when it comes to US sanctions and the potential for penalties. So we'll talk a little bit more about that and kind of how enforcement works. But before we get there, I just wanted to walk through a little bit some of the statutes that cover the sanctions regime. This is not all of them, but these are sort of the main ones that you'll see invoked. And those include the Trading with Enemy Act, which has been in place for decades, and is really focused on nations that have been either declared to be at war with the United States or have been treated as foreign combatants. You have the most common sanctions statute, the International Emergency Economic Powers Act, or IEPA as it's commonly used. That is the statute that is usually the basis for most sanctions regimes, and certainly the ones that have been imposed most recently in Russia. That requires the President of the United States to submit a declaration to Congress that there is an international threat to the foreign policy or economy of the United States. For example, the first indication of that was the Iran hostage crisis in 1979, followed by repeated declarations with respect to the Iranian regime. There's also the Global Magnitsky Act, which is becoming more and more common with respect to public corruption and human rights abuses. And you're seeing an increase in the number of sanctions that are imposed on that basis. And finally, maybe the most recent one is the Uyghur Forced Labor Prevention Act, which, as the name implies, is really targeted at forced labor issues in China. Now, all of these sanctions regimes present kind of a complicated web for in-house counsel to navigate, but they're all implemented in roughly the same way. So the president, invoking the authority that's given to him under one of these statutes, adopts an executive order. The executive orders typically will contain the broad strokes of the prohibitions, and then may focus and drill down on specific restrictions that are imposed on US companies or US persons. Typically then what will happen is that the executive order will also empower the Secretary of Treasury, usually through the Office of Foreign Assets Control, that's what you all love to know, at OFAC, or the State Department, or the Commerce Department, to adopt more specific regulations And that's often what you have to look to for guidance in terms of what's specifically prohibited. So if we move on to the next slide, we can talk a little bit about the kinds of sanctions that are generally imposed. So it's helpful as we talk in particular about the Russia sanctions, but also generally when you're thinking about it. Sanctions can be sort of as varied as you can imagine in terms of their consequences for the designated party. So the most significant is what we call designation as a specially designated national. And those of you who have dealt with sanctions issues, and it seems like there are quite a few who are familiar with that term. An SDN is essentially, an SDN designation is essentially a complete block. US persons and US companies are not allowed to transact with any SDN barring either a general license, which authorizes any transactions of a certain type, or more likely a very specific license to deal with the SDN. So that's the most severe or restrictive form of sanctions that you'll see. And you'll all become quite familiar if you've seen with something termed the SDN list, which is, as the name would imply, sort of just a broad database of all the entities that have been designated. Next, there's also the sectoral sanctions and the sectoral sanctions identification list. This is more of kind of a tailored approach to sanctions. It's not necessarily a complete block, but when companies or foreign entities or foreign persons are designated on the SSI list, as it's called, there you will have, for example, there may be restrictions on the types of debt or equity transactions that you can engage in with an SSI. So those are more menu-based form sanctions that are that allow a little bit more of a tailored approach than the SDN designation. The next form, which in some ways can be the most disruptive to businesses and in-house counsel's work, are the correspondent banking sanctions. We all know the importance of sort of being able to transact globally with the global financial system and how critical the US financial system is to that. And US sanctions frequently leverage the role of the US financial system as often the clearinghouse for most international transactions by cutting off foreign financial institutions' access to US banks. So as a consequence of that, when you have broad-based correspondent banking sanctions in a nation, it can often be difficult for consumers or counterparties to contracts that are located in those nations to make payments in US dollars or to companies in the United States. The final ones are secondary sanctions. Secondary sanctions are sort of the most nuanced of the bunch. They restrict particular types of transactions, such as, for example, in Iranian oil, or with respect to computer parts. And essentially, they put companies to a choice. They say, if you desire to transact with the US market, you will curb your actions with respect to these types of transactions with designated entities. Those are typically enacted in conjunction with other forms of sanctions. So the next natural question, and one that I often get in my practice, and I'm sure Jeff does too, is who exactly are bound by sanctions and who's covered? You know, the obvious answers are obviously US persons, and that's defined in the regulations to be any US citizens or permanent residents. Any entities obviously formed under the law of the US. And one that often trips people up are persons who are located in the US, but who may not be US nationals. So that's sort of the obvious category. But the next two, I think, are ones that can often be confusing to people who aren't familiar with sanctions, and that's namely foreign persons and corporations. The US government has taken the position, and Shai mentioned that I was a federal prosecutor. I have prosecuted cases on this basis, that foreign parties or corporations who attempt to or do violate US sanctions are subject to penalty, including criminal prosecution, and that their sanctions laws and the laws that attend to them, like money laundering or bank fraud laws, have extraterritorial application of sorts. In other words, simply because an individual is sitting in another country, that does not mean that the US government views them as beyond the reach of sanctions. And then the final piece is what OFAC refers to as the 50% rule. The 50% rule is what is OFAC's way of trying to deal with a very common evasion tactic, which is basically shell companies and the creation of different entities to avoid sanctions. And so the rule that OFAC's adopted is that if a foreign entity or any entity is owned, majority owned or 50% owned by either one SDN or one SSI or a combination of SDNs and SSIs, then for purposes of sanctions, it's treated in the same way as those SDNs or SSIs. So in other words, if a company is 50% owned by an SDN, then the company is viewed as an SDN. If it's 50% owned by an SSI, then it'll be viewed as an SSI. So that's kind of the broader background of how sanctions are applied. Before we turn sort of to the more recently Russia-related sanctions, we had another poll question that we wanted to throw out about this subject. Maybe we can put that up. While Shai is pulling up the poll question, I will say one of the things that we were talking about before was the ways in which the foreign policy focus of sanctions really drives the narrative. And the Russia sanctions are probably the best example of that in some ways, because they are ever evolving. They emerged rapidly in response to what was a emerging threat through the invasion of the Ukraine. And it seems like many of you have already had to deal with it, and so have kind of felt the pain of that, of how quickly those move. In fact, just this morning, OFAC put out another set of sanctions-related executive orders related to Russia. So they move quickly. But as maybe many people don't realize, sanctions with respect to Russian aggression has actually been in place for many years. It started in 2014 with the invasion of Crimea, and then a separate set of sanctions were later imposed in 2022 with respect to the Ukrainian invasion. They cover all of the categories that we've talked about before. So there are Russian sanctions designating SDNs, there are sectoral sanctions, there are broad-based industry prohibitions, there are regional bans, and there are investment prohibitions. Really, it's the full menu of sanctions. And so we're going to talk a little bit just in the next few slides about some of the specific types of sanctions that the US has imposed. So the first bucket are the SDNs. OFAC has designated dozens of Russian companies and persons as SDNs since the invasion has begun. Some of them have been individuals like Vladimir Putin and members of his family or his inner circle, but some of them are also significant pillars of the Russian economy. For example, some of the largest Russian banks have been designated, Sberbank, Alfa Bank, among others. And then large-scale Russian companies. And I think what's important to notice on this list, and we just put a smattering of examples, is they span industries from the traditional, the diamond mines, to the more fintech space. And so what you are seeing is, and you'll hear this theme often, is the US government anticipating and evaluating a specific threat and then trying to enact sanctions that bar that. Now, they're not always super effective in doing that, but one of the ways in which they're doing that is by identifying specific threats and specific companies and sectors and designating them as SDNs.
Sid, I've got a question for you.
Yeah, please.
So I understand. So with Russian companies, I know how they kind of identify a particular country to add to the list, but I've never really understood how they pick specific banks. So, Russian banks, obviously, they have thousands of customers. How do they pick which of the banks to impose sanctions on? Because presumably lots of the banks have both, sanctioned entities and non-sanctioned entities, just like most US banks have criminals and non-criminals. So, I'm just curious if you happen to know the process that goes into deciding which of the banks are sanctioned and which are not.
Yeah, so the OFAC designation process is one that it ingests a lot of information from different parts of the US government, but the ultimate driver of those designations is which banks will have the most significant impact on the economy that they're trying to target. And so you should always remember sanctions are goal-oriented, right? And so in the case of financial institutions, what really is the US government is trying to do is target ones that will have the most critical and most sort of speedy impact, particularly when you're dealing with a situation like Russia, where the sanctions are intended to combat an acute threat, namely the aggression. So what will usually happen is OFAC will receive information from all different parts of the US government, including the Department of Justice, the State Department, various intelligence agencies, which will sort of flesh out the picture of, one, what kind of sanctions evasion activity are they engaged in, but two, also how critical are they to the economy. And based on those kinds of factors, they'll pick the banks that they want to designate. But it should be clear, every bank that they designate, they have to have a showing that the bank will be engaged in ongoing sanctions evasion activity. So, and what's interesting about that is that also kind of plays into the different types of sanctions that they impose. So, for example, there may be a bank that is engaged in that type of activity, but that for various geopolitical reasons, the US government is not prepared yet to issue a full SDN block. So they may, in that circumstance, for example, designate it as an SSI. So a great example of that in the Russia context is Sberbank began with SSI designations, which when those did not work, were steadily ramped up to SDN designations. So let's talk a little bit on the next slide about some of the SSI limitations. So if you'll remember, SSI is simply sectoral sanctions. So it's a determination by the Treasury Department that particular sections of the Russian economy present challenges to the national security of the United States. And then within those, certain financial institutions, for example, or companies are problematic. And so the most common form of SSI sanctions that have been used in the Russia context are debt and equity limitations. And so really what these are and why they can be so nettlesome for in-house counsel and business people is they place limitations on the maturity dates for debt instruments or equity transactions that can be imposed. And that can have broad sweeping implications for a company. For example, debt is defined to include lines of credit. So if you are engaged in a commercial transaction with a Russian client who fits within the SSI designations, your payment terms going forward can't give them more than 14 days to pay for goods. That is a potential violation of an SSI penalty. And in fact, OFAC has taken that position in recent enforcement actions where they penalized US companies for accepting payments late from Russian SSIs. So we'll talk a little bit about kind of how all this, practically speaking, impacts life at a corporation. But one of the ways in which we've already seen it is by forcing people to really look at their payment terms and often having difficult conversations with their counterparties in Russia. OFAC has also implemented correspondent banking and industry prohibitions, and we'll see some of those on the next slide. There's CAPTA, which is a law that essentially, as we've talked about, cuts off Russian banks, particularly Russian banks, from the US financial system. The biggest impact of that we've seen is that it effectively prohibits US dollar transactions, which means that Russian companies who bank with those financial institutions usually can no longer make US dollar payments, which is of course critically important for US companies who are expecting to get paid, or in fact, companies around the world who typically get paid in US dollars. Another significant ban is the import-export bans that have been adopted. And these are another example of something that kind of came out of the blue, but there's an obvious purpose to them. So they fall into a couple of buckets. One is the luxury good export ban. In other words, US persons are not allowed to export what are termed luxury goods, as defined by the Department of Commerce, to anyone in Russia. Also, U.S. persons are not allowed to import certain things, including fish, seafood, alcohol, for all the Russian vodka fans out there, or diamonds of the non-industrial sort. And then there are energy import bans from Russian oil. And I think if you've read the news, you've seen sort of the hemming and hawing, for example, with respect to the EU about Russian oil imports. Each of these are an example of kind of the balancing, Jeff, that we were talking about earlier in terms of foreign policy goals. So the luxury good export ban is very specifically targeted at Vladimir Putin and Russian oligarchs who happen to be significant consumers of luxury goods. But at the same time, it presents a real complication for companies who are engaged in that kind of business because it happens suddenly. And the nature of the goods, while the regulation says luxury goods, there's sort of a complicated web related to the Commerce Department and pricing that requires you to sort of look at each of your potential shipments and make a judgment. And in a lot of cases, those judgments are complicated enough that companies simply elect that we're going to treat this as a blanket ban. So that's an example of that. And it also brings in a concept in sanctions law that's pretty important, which is known as re-exportation. Re-exportation is essentially a roundabout way of exporting. So sanctions reach not only the direct export. So for example, you can't send a fur coat from New York to Moscow. But the other thing you're not allowed to do is you're not allowed to send it from New York to Budapest, knowing that it's going to ultimately go to Moscow. That's what we refer to as re-exportation. And the regulations ban that as well. So in a lot of transshipment situations, companies find themselves on the wrong end of an OFAC information request because goods that they ultimately ship to a non-sanctioned entity find their way to a designated nation like Russia or Iran.
But if you're a U.S. exporter and you export your goods to Budapest, you're not responsible for the decision that's made by the purchaser of your goods. I mean, if they on their own decide to re-export into Russia, can you be on the hook for that?
Well, so that brings up a little bit of the point that we talked about before, which is the strict liability implication of sanctions. As a technical matter, because they're strict liability offenses, if you are in a situation where you're exporting to Budapest, but your goods ultimately, even unknowingly to you, find their way into Russia, you could find yourself in sort of OFAC's crosshairs. Now, practically speaking, when that happens, usually what corporations do is engage with OFAC and explain the circumstances. And one of the things, Jeff, we're going to talk about, I know, is the importance of having a compliance program and the importance of having goals. So one of the things that you present to OFAC in those situations where you've got the unwitting Budapest to Moscow shipment is the checks and balances that you have in place to try to prevent that from happening and how this was not a systemic problem or an innocent mistake. So as a technical matter, yes, a U.S. company could file itself on the hook in that situation. But as a practical matter, as long as they're taking their compliance obligations seriously, that's usually a pretty good argument for them to avoid penalty.
So yeah, I guess if you're shipping all of your fur coats to southern Greece, it'll be harder to say, oh, I just assumed they were all wearing them on the islands of Greece. I had no idea they were going to be reshipping them.
That's absolutely right.
Like a fact-specific inquiry would take place, I guess.
As lawyers love to say, exactly. So the next set of sanctions that I think have been particularly significant are the regional bans. And some of these are pretty easy to understand. They simply prohibit U.S. persons, for example, of sending any goods or services to regions that have been subject to the invasion. So, Crimea or Donetsk or Luhan. But some of them are more nuanced. For example, the U.S. government has adopted a U.S. banknote export. So in other words, U.S. persons are not allowed to export U.S. banknotes to anyone in Russia. Similarly, there are investment bans prohibiting U.S. persons or companies from engaging in investment activity in Russia. And the most, I think, sort of applicable broadly for most of the folks on the CLE is the category of services ban, which in essence empowers the Secretary of Treasury to designate services that he determines to be a threat as prohibited. And so when OFAC initially announced that ban, many people expected that they would immediately follow up with what services they're talking about, which seems like a logical leap. In fact, OFAC left that to as a mystery for many months and only announced the first category of services relatively recently, and those were accounting, trust formation, corporate formation, and management consulting services. And each of those are defined pretty broadly. But again, they came back to sort of the policy goals, which were to impact Russian oligarchs and the high end of the Russian economy from being able to form corporations.
Trust formation, that's legal services. I don't know, it's all fun and games when you ban fish imports, but imposing sanctions that affect law firms, I don't know about that.
I agree. A lot of lawyers are sweating after that. So that's kind of a summary of the sanctions, and we'll talk, sort of about specific applications of them as we go on. But OFAC and the Department of Justice and its enforcement of sanctions is kind of just one piece of this. Jeff, I know you can tell us a little bit about sort of FinCEN and how the Bank Secrecy Act works.
Yes, I can. So a little bit of background on the Bank Secrecy Act. It's a much more recent body of law. It was established in 1970, and it was really focused on combating money laundering, which historically hadn't been a direct, separate focus of law enforcement. And it imposes a bunch of requirements on financial institutions. And before I get into all those, I'm going to talk a little bit about what a financial institution is, because some people on the call probably know that you work at financial institutions because it's a bank. But in fact, there's lots of financial institutions, and sometimes people interact with financial institutions without even knowing it. So I'm going to jump to that slide. And I think this is kind of a classic lawyer how to not do a PowerPoint slide. It's impossible to read and has a million categories. But the point that I am trying to make in putting this up is just there's a lot of financial institutions that are not banks. And this includes travel agencies. You probably wouldn't have guessed that the Bank Secrecy Act applies to a travel agency as a financial institution, but it does. And there's pawnbrokers and insurance companies, telegraph companies, people that do real estate closings. And then there's some other categories that you might have thought of as implicated by the Bank Secrecy Act, but are clearly not banks, like casinos and Indian gaming operations. So this leads me to the next polling question. So Shai, if you can put up the next polling question. So this is just asking people if they know that they work at a financial institution. The options are no, yes, I work at a bank. Yes, I work at a non-bank financial institution. And I guess this last one's supposed to be a joke. It's like an inside sanctions joke. I'm unsure, is Sberbank a financial institution? And you may recall that's one of the sanctioned Russian financial institutions. So go ahead and answer those questions. And while you're doing that, I am going to give a little bit of background on the basic requirements of the Bank Secrecy Act. So I'm going to march through these, but also I'm just going to talk about what they mean, because it's easy for people to kind of speak in jargon about these Bank Secrecy Act requirements, but it's helpful to just have a more practical understanding about what they mean. So the first is that you have to have an effective Bank Secrecy Act compliance program. And that means a couple of things. First of all, it means you should have a policy written out, like a typed out written policy about what your institution is doing to prevent money laundering. It also means you have to comply with the policy. One huge mistake that I see, especially with very new startup type companies, is they'll type out this great sounding policy, or they'll get it from the web or something, and they'll be like, great, now I have a policy, but they won't be complying with their own policy. So it's important to make sure you both have a policy and you have procedures that enable you to comply with your own policy. You also have to have effective customer due diligence systems and monitoring programs. So monitoring programs are basically programs that monitor the transactions that you engage in. So this is most commonly used by banks and fintech companies. And basically the programs have become quite sophisticated. And what they'll do is they'll look at all the transactions going in and out of, for example, a bank account, and they'll notice certain patterns that have been identified as indicia of money laundering. So for example, if you see, or if the program sees 10 cash transactions all going into a bank account, followed by a wire the next from different ATMs all around the city, followed by a wire to Mexico, and that keeps happening, that's been identified as something that might be smurfing. So smurfing, named after Papa Smurf and his assistants, it's the notion that you have a bunch of people that are dealing drugs for a drug organization. They go to a bunch of different ATMs. They all do deposits into the ATMs, and then that's transferred back to the drug cartel in Mexico. And there's numerous examples of things that are red flags, and these computer programs just automatically pick them up as part of the monitoring process. Then separate from monitoring is screening. So screening relates to sanctions and OFAC. And this actually relates to one of the questions that I saw in the chat. So one of the questions in the chat that was asked is, in connection with sanctions, do you have to actually screen the transactions just before they even occur? And that's a fundamental difference between sanctions compliance and money laundering, Bank Secrecy Act compliance. So sanctions compliance is all about doing the screening upfront in real time and stopping the transaction from taking place. In contrast to that, the Bank Secrecy Act monitoring is focused more on transactions that have already taken place that may indicate that an account is being abused and that money laundering is occurring. And often the actions that take place as part of your anti-money laundering program will happen after the transactions occur. Whereas your sanctions compliance program ideally always has to stop the transactions from even occurring. And that's connected to the strict liability issue. So if you're in a strict liability regime, you've already to avoid the liability. In addition, you have to establish an effective suspicious activity monitoring and reporting process, which is the process of actually filing what are called SARs, or suspicious activity reports, with FinCEN. And you have to develop a risk-based anti-money laundering program. And what that means is when you create an anti-money laundering program, you take into account the risk profile of the different types of customers that you have. So, for example, if you have customers that are in Belarus or in a country that frequently does transactions with Russia, you may apply a heightened degree of scrutiny to those account holders as opposed to other account holders that are more, retail customers that are just natural persons that live in New York, for example. So now I want to talk a little bit about the impact of the Russia sanctions on the FinCEN regime. So there have been several announcements that have been made by FinCEN. And I guess a little inside baseball, when you see this little site at the top to FIN 2022 Alert 1, that's how you identify any specific FinCEN announcement. So FIN 2022 Alert 001 was all about suspicious activity reporting. And this, again, is important to understand the difference between OFAC requirements and the requirements that are imposed by the Bank Secrecy Act and FinCEN. Because what FinCEN said is that a financial institution has to file a SAR even if they filed a blocking report. So some companies have made the mistake of thinking, I blocked an account because I thought it may be a transaction that would violate a sanctions program. I notified OFAC of that. I'm done. But it's important for them to know they need to also file a suspicious activity report, which is separate, is filed with FinCEN, and is focused on a different thing. Instead of being focused on the sanctions regime, it's focused on preventing money laundering. In addition, sometimes information that can be relevant to whether a transaction is suspicious may go beyond what was relevant to the blocking report that's filed with the OFAC. So it's important when you file the SAR report that you include not only the OFAC information, but any other information that potentially is indicia that the transaction is suspicious. And finally, as somebody who used to work with SARs, I know the government gets overwhelmed. So they've started saying, look, when you file your SAR, we want you to actually include as a key term a phrase that relates to the FinCEN announcement we've made. So if it relates to the Russia sanctions, you actually have to type in the phrase FIN 2022 Russia sanctions, and that'll help be a red flag for them that when they get 100,000 SAR reports on the same day, they can quickly identify the reports that relate to the Russia transactions. The next FIN alert related to real estate, luxury goods, and high value assets. And this was really focused on the oligarchs. So there's been a lot of press coverage about oligarchs' yachts and transactions involving real estate and luxury goods. And it's interesting because the anti-money laundering regime actually applies to unlawful transactions. And the money laundering statute basically says if you do a financial transaction with proceeds of a crime, that's money laundering, and we can then seize the asset. But a lot of assets didn't become subject to seizure or forfeiture. There weren't subsequent financial transactions. So for example, if you own a diamond and that diamond becomes subject to a sanction, well, just put it in your pocket. Don't do any transactions with it, and you're probably fine. You're not going to. So what got the oligarchs into trouble with the yachts is when you own a yacht, it's sitting there floating in the water. And if you don't, scrub the barnacles off the outside and you don't pay the fees for where your slip fees for the yacht, if you don't pay the people that are working on the yacht and driving it around, then the yacht will start to deteriorate. So there were subsequent financial transactions that related to those luxury goods. And that's part of why the US government, now with the assistance of other governments, has been going out and starting to seize things like yachts and luxury vehicles, because after the sanctions were imposed, there were subsequent financial transactions. So this is really the practical information that you can use as in-house counsel to ensure that you're complying with the Bank Secrecy Act. And a lot of these same rules apply with equal force to the sanctions, to ensuring that you comply with the sanctions programs. So the first is you need to update your written compliance policies. If you look at your compliance policies, a lot of times they'll reference specific sanctions programs and specific red flags. Now that FinCEN has identified new red flags, and now that OFAC has identified new and imposed new sanctions rules, you need to go back and update your compliance policies to include those red flags and include those new sanctions programs. In addition, you need to verify that your monitoring programs are updated to flag transaction evasion transactions. So what that means is you may have monitoring programs that have been pre-coded to identify certain types of patterns of unlawful conduct. And I talked about one earlier with the smurfing of drug transactions, but you need to make sure that you go back and look at those programs and update them to include things like, is a transaction going in and out of Belarus? It may be that currently your programs are focused on, for example, North Korea or Iran, but are not focused on transactions that are tied to other jurisdictions like Russia and Belarus. So you need to go in, tweak your screening programs to make sure that they're identifying that. You also need to train your employees. So this is another thing that we see is that high-level executives will go in, they'll type out a new compliance program, and maybe the head of legal, the head of compliance is aware of the changes that have been made, but sometimes people out of the field don't understand what those changes are. So you need to go out and train your employees to ensure they're going to comply with the.
Jeff, let me ask you a question real quick. You mentioned, I think when we got cut off, ensuring that relevant employees are aware of sanctions. Are there, in your experience, are there kind of best practices with respect to communicating those policies to people on the front lines? How should in-house counsel handle that kind of activity?
Yeah, so I think the critical thing is to identify anyone who can be initiating contact or negotiating or finalizing an agreement that relate to any of these sanctioned entities. So, if you're a company that has business development people that are traveling around the world and engaging and initiating contacts with people in different countries, they definitely need to be trained, even though compliance isn't part of their function and legal isn't part of their function. I think it's critical for them to be aware of these changes. Certainly everyone in the compliance function needs to be aware. And in addition, some companies outsource their parts of their compliance function to third parties. So for example, they may bring in somebody to help them update their risk management policies or to update their monitoring systems. So they need to make sure that the people that are doing those updates are aware of changes to the company's policies that relate to Russia and Belarus. So another thing that it's very important for companies to do is just be aware of what are red flags for suspicious activity. And as we go through this, I think one thing that is important to keep in mind is again, the difference between the Bank Secrecy Act and sanctions programs, because one thing that companies often err in implementing their policies that relate to the Bank Secrecy Act is that they'll view a problem as just an OFAC problem. And so what that can mean is they focus on, on technicalities like the 50% rule that you gave, or they focus on, is this a transaction that directly involves somebody who's been sanctioned? But often what they fail to then do is take the additional step and say, well, even if it doesn't appear to technically violate one of the sanction programs, is it suspicious? And often the answer is yes, it's obviously suspicious. The reason why you thought it was very close to the line when you were doing your analysis of whether it was permissible under the sanctions regime is because it was pretty suspicious. And so you can file a suspicious activity report even when you've concluded that a transaction is perfectly permissible under sanctions law. I'm going to not spend a huge amount of time going through these detailed questions about the examples of suspicious kleptocracy-related activity or the red flags for suspicious activity or suspicious sanctions avoidance transactions. But the critical thing, and just to take, for example, the first example under the slide that we're looking at now that relates to sanctions avoidance transactions, if you have an account that is connected to Russia or Belarus, even if it's not opened by someone on the sanctions list, and they suddenly experience a rise in value that's being transferred into the account without a clear economic or business rationale, that may not violate any sanctions prohibition. You may conclude that there's no reason to think that it is a transaction with an oligarch who's on the sanctions list, but it still is likely to be suspicious, and it may warrant filing a suspicious activity report because it can be an indirect effort to, in some way, siphon money out of Russia. And similarly, the third example here, newly established accounts that attempt to send funds to or receive funds from a sanctioned institution. You may have an account holder, they try to receive funds from a sanctioned institution. You say, oh, we need to block that transaction. So you block it. But then that account holder, they may subsequently try to engage in completely permissible transactions. You still should view that account as being suspicious, and that's still a red flag for other transactions in that account, even though it may not, even though the additional transactions may have nothing to do with a sanctions violation. So let's quickly talk about sanctions enforcement.
Thanks. And, I think the first thing that we talked about was sort of strict liability offenses. So that relates to civil penalties that are imposed by various regulators. The most common of which is OFAC, but that often when OFAC takes an action, it dovetails that with FinCEN or state regulatory authorities like the New York Department of Financial Services. All sanctions violations carry the possibility of civil penalties. And as we mentioned, because they're strict liability offenses, it's not a defense to say it was unwitting or it was a mistake. What is sort of critical, though, is when you are engaging with OFAC after there's been a sanctions violation detected, that's when all the policies that Jeff was just talking about become really critical. Because while OFAC has the authority to impose penalties with respect to sanctions violations, they also have the discretion to impose lesser penalties or forego a financial penalty altogether. And really, the keys to guiding their determination is the good faith efforts that the company made to avoid sanctions violations. And so it's critically important to try to get ahead of it and to be thinking proactively in your business about ways in which you're presenting these potential risks. And so one great example is the compliance monitoring that Jeff talked about. That's a standard sort of requirement that OFAC looks at right now. Another one, which is all too familiar to in-house counsel, is staffing and resources provided to compliance. OFAC certainly takes a dim view if you have a compliance program in name only, so to speak. But as as sort of like technology expands and sort of develops, OFAC expects companies to do that as well. And so IP blocking has become an increasingly standard form of monitoring that OFAC expects. In other words, being able to track your customers and where they are accessing your websites from, for example. But just as with everything else, OFAC is sort of looking at those through an evolving lens. And so you have IP logs, which were a tool for law enforcement and regulators to track down bad actors. Then those bad actors start using VPNs. And so OFAC expects people and expects companies to keep abreast of current trends in technology and current trends in sanctions enforcement. And those are the kinds of things that you'll have to present if you do find yourself in a situation where there's a sanctions violation. So that's the bucket of civil penalties. Criminal enforcement is also something that I think companies have to be aware of. There's often an understandable but misguided impression that the Department of Justice either isn't enforcing sanctions as vigorously as it will, or isn't really focusing on certain industries. While I was a prosecutor here in New York, I had several sanctions prosecutions that sort of spanned industries. But the most common of them were always predicated on the use of US market, the use of the financial system here. And so when you have willful violations of those kinds of sanctions, that's when you can trigger DOJ review and ultimately potential criminal indictments. And those indictments can be of individuals. For example, I prosecuted a foreign banker for violating US sanctions. But at the same time, they can also be for the corporate entity. We not only prosecuted the banker, we also prosecuted the bank. It's important to realize as well that it's not just DOJ who's in this sphere. State prosecutors, particularly here in New York, do their best to enter the sanctions regime. And it's also important to remember that indictments are not the only reason. We've all heard about yachts being seized, but asset forfeiture is a significant piece of the enforcement regime. And Jeff, I know you had a lot of sort of forfeiture experience when you were a prosecutor.
Yeah. So asset forfeiture can be kind of tricky. It's really, the idea of asset forfeiture is that it is a tool that can be used to ensure that criminals do not profit from their criminal acts. So, the main people who need to worry about this are the criminals. But also, non-criminals can get on the hook if they engage in a transaction with a criminal. And in particular, if you're in-house counsel, you should just be aware that if you, for example, if you purchase assets and the assets are originating from somebody who's on the sanctions list and subsequently become subject to forfeiture, the government may say, look, you should have known that this was an asset that was in some way tied to somebody who was subject to sanctions and therefore was potentially forfeitable. So, we know that you're not a criminal. You just paid $90 million for a yacht, but sorry, we're taking the yacht and you don't get your $90 million back. You're just out of luck. So you don't want to be in that situation. So the upshot is, if you're engaging in any type of transaction that you think may in some way implicate anybody who is subject to sanctions, you should really do your due diligence to ensure that you're not acquiring an asset, whether it's a yacht, whether it is a security or some other financial asset, or any other type of luxury good or jewels or anything like that that may subject you to asset forfeiture. And even if the government concludes, you didn't commit any crimes and you didn't violate the sanctions regime intentionally, and you had no reason to specifically know who it was that had participated in the transaction with you, if they conclude that you generally had reason to know that this could be subject to forfeiture, they could take that from you. So do your due diligence.
Yeah, and I think it's important to realize that the U.S. government does sort of, not only does it take sanctions very seriously, but it looks for sanctions evasion activity in all types of industries. And so there have been enforcement actions, whether they're designations, civil penalties, criminal enforcement, in places where you may not expect, including film studios or jewelers or textile companies. And we've all heard about, as Jeff mentioned before, the seizure of kleptocrats' yachts. But that can be more broad-based as well, and it can involve seizures of high-end luxury goods like paintings or even cargo ships. So you really have to, you really not only have to take these issues seriously, but you have to be aware of how broadly the U.S. government is choosing to pursue these kinds of sanctions.
Yeah. Also, one thing.
So I know we had some questions in the chat.
Asset forfeiture also can apply to living assets. So there have been a bunch of cases that involve like the seizure of thoroughbred horses or the seizure of sheep. So even if you're buying anything that might be worth a significant amount of money, even if it's something alive, just be aware that it could be seized. And of course, then the government's going to have to figure out, how to feed your horse.
So I know we had some questions in the chat, but Shai, I think this would be a great time if folks have questions to get into those.
Yes, definitely. So first of all, thank you, Sid and Jeff, for a fantastic presentation. Lots of great insights and advice and tips. We have a bunch of great questions. In your experience, when an entity or individual is placed on a sanctions list, how likely are they to come off the list? And are these individuals or entities usually alerted that they're on a sanctions list?
Typically what happens is after OFAC has made a determination to sanction an entity, they issue a press release. That press release published on their web, and it names the entities that have been sanctioned, and then the OFAC database containing SDNs is updated. So OFAC maintains its own sort of searchable database that you can look at. And then in a helpful sort of tool, OFAC maintains basically like an email mailing list where it will email folks whenever there's been kind of a new designation or new action taken. So that's the way that normally you're engaged. I will say that designated entities often sort of get a heads up that it's coming, because OFAC will engage with them as part of an investigation in order to try to get documents. So for many of them, it's not a surprise, but that is not to say that there are not people who are caught off guard.
Do people who are on how do people who are on the sanctions list, or institutions or entities or individuals, how do they get off the sanctions list?
Yes, no, so there's two ways off the list. One is you can challenge an OFAC designation in court. So you can litigate the question. You should be aware that courts are very deferential to OFAC's determination. And OFAC is allowed to rely, for example, on classified information in defending its designations. But you are able to litigate that. You're also able sometimes to negotiate with OFAC. And in particular, negotiations sometimes will cure, for example, the 50% problem. So in the case of certain Russian oligarchs, for example, companies that they were involved in, that they may have owned 51% stakes in, were able to get off the sanctions list through negotiations with OFAC that involved a sort of a disgorgement of their stock. And then finally, sometimes OFAC decides that a company is no longer a risk and will take them off.
So we have like a bunch of good questions coming through. Are we permitted to hire independent contractors that are based in Russia and paid through a bank based in Russia?
There's a lot of nuance to that question, so it'll be hard to give you sort of a full answer. But the factors that would go into that are things like what currency are the independent contractors going to be paid in? Are the transactions involving the Russian banks going to involve transactions that originate here in the United States? Are there any U.S. persons involved in making those transmittals? So that's a great example, frankly, of the kinds of questions that we get, and sort of the in turn factual questions that we have to ask in order to get an answer.
What do U.S. persons do if they already have investments in Russia when the regional investment ban is implemented?
Well, so we've got a lot of OFAC specific questions. So Jeff, jump in at any time. But generally what happens is OFAC will provide for a winding down period. So a period in which U.S. companies are allowed to unwind transactions that would otherwise prohibit the sanctions. But to be clear, that doesn't always happen. So, for example, the luxury good ban was affected immediately. The only way that you could get around it is if you had actually, your fur coats already on a boat sort of destined for Moscow. So typically, though, with the more complicated financial transactions or investments, there is a wind down period that OFAC provides for, and you just have to sort of make sure that you are unwinding in sort of with that schedule in mind.
Yeah, and I've actually spoken to some in-house counsel that have affirmatively reached out to OFAC to discuss the issue, and their perception was that OFAC was unusually responsive to them. I think in the past there have been issues of, you send a question in and sometimes you don't get an answer very quickly, or you get a vague answer and you don't know what you can do. But I think in this instance, from what I've been hearing, at least so far from in-house counsel, OFAC's made an unusually vigorous effort to be very responsive in helping companies figure out how to do the wind down process. So a lot of people, hire outside counsel to engage with OFAC to kind of negotiate how that wind down process can occur.
Got it. Speaking of in-house counsel, do you know of any good resources that could serve as a checklist to enable in-house counsel to stay up to date on sanctioned entities, sanctioned individuals, so that they're, a little bit ahead of the game?
Sure. I mean, there's a lot of private companies that offer that type of service. Generally, they're a waste of money, but it kind of depends on the type of service that you're getting. So one thing that some companies will do is send out updates concerning FinCEN's announcement of changes that FinCEN is making, but FinCEN's announcements themselves are pretty good. So, and they're not, they're made relatively frequently, but you can check them and it's not that hard to stay abreast of them. And you can even register so you get an automatic email when a new FinCEN alert goes out. So what I would do is just sign up for those alerts. And that's, signing up for those alerts is actually one of the things that the agencies themselves recommend. So, as a company, if you're responsible for keeping up to date, you should sign up for alerts directly from FinCEN. And they're pretty good about even, identifying with some specificity new red flags that they suggest and that type of thing. The one exception to that is it can be very helpful to have some third-party service, unless you're a very large institution, do things like update the automatic screening information that is used for your compliance with OFAC. Because when that gets changed, you want to immediately update your computer systems. And if you don't have somebody that is like checking that all the time and is very good at updating your screening programs, you can get out of date or behind, or the list that you're screening doesn't include all the variations of the Russian name. And that's something that I think can be an effective service. So if you have an electronic screening service, I might find a third party that can do automatic updates to the screening program that you're using.
Got it. Next question. Can you speak about the possible implications of a foreign subsidiary in China with an ultimate U.S. parent company which operates autonomously from the U.S. entity? Everything is separate, separate payroll, email, etc. Selling goods manufactured in China into Russia and or to sanctioned individuals or entities, like possible sanctions and implications, I guess, for the U.S. parent with this subsidiary in China that might be, could potentially be violating sanctions law. Does that blow back on the parent? How does that work?
That sounds like quite a law school exam question. I'm tempted to just dump that on Sid. But it sounds like in terms of issue spotting, one issue is going to be whether you focus on primary sanctions versus secondary sanctions, right? A second issue is that you should always keep in mind is the U.S. isn't the only, like we've really focused on the U.S., but the U.S. isn't the only country that imposes sanctions for transactions with Russia. So you definitely are going to want to, if you have an international company, you're definitely going to want to focus on the UK regime as well. And then I guess the third question is just a question of whether there's a U.S. person involved. And that I'll let Sid talk about.
Yeah. So, that determination is a little fact specific. I think one thing that it's important to remember in the context of the U.S. person inquiry is all of the sanctions prohibit not only directly engaging in a transaction that would be violated, but also agreeing to, attempting to, or causing a U.S. person to. And so when you have these parent sub situations, a lot of times what the Department of Justice and OFAC's perspective will be to focus on how much knowledge the U.S. parent have as to what was going on, and what role did they play. And they take a pretty restrictive view of that. If you are a U.S. company with China, it's not unlike the way that they perceive the FCPA. If you are a U.S. company with a subsidiary that's engaged in conduct that could be violating sanctions, OFAC or the Department of Justice will frequently invoke either a conspiracy theory or an indirect sanctions theory to reach the U.S. parent. So I think anytime you've got sort of a corporate structure that includes an ultimate U.S. parent or a U.S. affiliate, you have to be very careful about what kinds of transactions you're going to engage in.
Okay, got it. All right, we still have a few more questions. Are there any FinCEN and or OFAC guidance for accountants, auditors, given the recent EO 14071 banning accounting services, I guess, out of Russia?
I'll just speak to FinCEN.
14071,
I was going to say at least with respect to OFAC, when OFAC banned accounting services provided to Russia, what it did was it also released a determination and a set of FAQs, which is something that OFAC does with some regularity, where they define what they viewed as to be accounting services. That's principally the way in which OFAC kind of generally issues guidance. As Jeff mentioned, companies are allowed to engage directly with OFAC to ask for specific guidance about activity that they're engaged in. That's always an option. We always urge clients to think carefully about that and sort of, let's walk through it, because obviously when you engage with a U.S. regulator, you don't know what questions they're going to come back to you. So you want to be thoughtful in your approach. But the best guidance about those kinds of things, particularly early, until there are enforcement actions to judge from, are the FAQs that OFAC publishes on its website, which also they will kind of give you notices of if when they send out their emails.
Yeah, and I'll just say those FAQs are super useful. Like a lot of times, if you just jump in and you start reading like an executive order directly, it can be very confusing. The FAQs they're very practically useful. also they're included in your CLE materials for this presentation today. So check them out if you have any questions, and there may be answers there that you'd find useful.
Yeah, awesome. Does anyone have any experience or guidance with handling ERISA 404B issues with Russian ADR/GDR programs with non-US investment managers?
Yeah, that one, unfortunately, I'm going to say my ERISA textbook is still stuck in law school. So I don't know that I'm going to be able to get into the the specifics of it. I mean, I think what I will say is ERISA plans fall under the same rubric, and they're generally speaking not general licenses that exempt the activities of ERISA or pension plans. And so depending on the countries in which you're operating or the way in which you're operating, you sort of have to treat those in the same bucket as general investments.
Got it. Where you have a Russian subsidiary, do you need to restrict incoming payments from Russian customers that originate through sanctioned banks?
The answer is yes, but you're not going to have much of a choice because U.S. financial institutions are some of the most aggressive sanctions police. They also sometimes are the ones who violate sanctions the most. But typically, one thing that they're usually pretty vigilant about is blocking banking transactions that come from sanctioned banks, and so you certainly have to be careful about those transactions, but often you won't be given the choice anyway. And Jeff, I'm not sure if you've had experience with that recently, but that's certainly been my experience.
Yeah, that's accurate.
All right. Okay, I think this is our last question. Do the current Russian sanctions prohibit a company from investing in a non-Russian entity that has Russian investors who are not on any OFAC or USG lists?
I think the answer is no. I mean, there's a chance there could be a prohibition if it's depending on the industry, but as a per se matter, you're not prohibited from investing in a company just because there are Russian investors in that company. There could be, except if you say, oh, and the company's in North Korea, or the company's, engaged in the export of fish or from Russia or something like that, then you could end up hitting a sanctions regime. But I don't think it's so broad that you would be prohibited from investing in a company just because that company had Russian investors.
All right. Fantastic. Thank you, Jeff and Sid, for a fantastic presentation and for answering all of our questions. There was a ton.